We're joined by Chief Justice Veasey, who wrote a very important decision in the Disney litigation back in 2000, reported at 746A second 244, Brem versus Eisner. And Your Honor, your court reviewed the first decision by Chancellor Chandler on a motion to dismiss, where he did dismiss the derivative litigation in a way that in and of itself didn't seem terribly out of the ordinary. He examined the relations between the directors and the allegedly interested folks, and also dealt with the second prong of Aronson. When the case came up to the Supreme Court, did you have any sense that it was going to turn into this seminal Delaware litigation?
No.
It was just another derivative action.
Well, it was more than that, but we never thought it would go to the lengths that it did.
And in the time that this case was being litigated, there was a lot of focus in the financial press, in academia, on executive comp. Was there a view, either that you had or you think maybe your fellow members of the court had, that eventually this case was going to be a meaningful opportunity for the Delaware Supreme Court to weigh in on executive comp decisions?
Probably not. I think we looked at this case as a very important case in terms of its facts. And it was a close case, as we said in this opinion, because it involved so much money, and it involved a process that was not clear in terms of what the board of directors did. And it also involved this complaint that the chancellor had dismissed that was a mess. We wrote in here,
Yeah.
the complaint consisting of 88 pages and 285 paragraphs is a pastiche of prolix invective, and it is permeated with conclusory allegations of the pleader and quotations from the media, mostly of an editorial nature, even including a cartoon. So we just thought that the plaintiff, we thought that the plaintiff had something here, but didn't articulate it well enough to let it go the way it was. And the complaint was a mess. And it wasn't clear exactly what the court did with it, because we found a few glitches in the lower court's opinion. And we found that there had to be something there because of what Crystal Grafe had said in the media after the fact, that he said something like, I wish I had done a spreadsheet, or I wish I had done something on the math, the economics of this transaction. But it was a mess.
And one thing that you commented on was the lower court's articulation of due care, of what was necessary to satisfy the duty of care. Do you remember that aspect of the decision?
Yeah, it was more of a cryptic comment that the court had made that we thought needed to be corrected, but it was not reversible error.
Yeah, you wrote, we conclude that the formulation of the due care test by the Court of Chancery in this case, while not necessarily inconsistent with our traditional formulation, was too cryptically stated to be a helpful precedent for future cases. The court below had talked about directors being reasonably informed,
Right.
As opposed to being informed of all reasonably available information. And so the court gave some guidance in that regard. With respect to prong one of Aronson, dealing with the independence of the directors, you affirmed and you dismissed that with prejudice, correct?
Can't remember.
You did. You did. So that prong one was affirmed and dismissed with prejudice. It was prong two, whether or not the complaint had raised a reasonable doubt as to the exercise of business judgment by the directors that caused the court to look at it very closely, look at the language employed by the lower court, and ultimately decide that while based on the existing complaint, you might have come out the same way as the lower court, you really wanted to give the plaintiff another opportunity. Tell me about that decision. Was that something that was at all controversial within the court?
Yes.
And can you speak about that discussion?
In general terms, yes. The court was very troubled by this case because of the magnitude of the dollars involved and the lack of clarity about the process that they used, and certainly the complaint didn't help. And we thought the complaint could be articulated more carefully. And I, for one, was concerned about these comments of Crystal Grafe, who was, I think, an outside expert. And they quoted him saying things, but we were not clear whether he was the expert to the committee that they relied in good faith on under Rule 141E, or exactly how that came about. So we were very reluctant to affirm the dismissal with prejudice. But we were very concerned about the fact that we almost never refer the case back to articulate it with a dismissal without prejudice, but that's the direction that we went. And you can see that Justice Hartnett wrote a concurring opinion in which you probably got the flavor that there was a lot of concern about the case, whether it should go forward or not. And so as we tried to do, we tried to come up with a unanimous decision. We had a unanimous decision, and we all thought at the end of the day this was a good way to resolve it.
And you expressly pointed the plaintiffs to Section 220.
Yes, and that's not the first case in which we did that, because we thought we had written other cases in which we said getting books and records under Section 220 was the way the plaintiffs could come up with the tools at hand in order to articulate something, because lawyers had said, out-of-state lawyers had said, Your Honor, how could we possibly articulate a Rule 23.1 complaint that would survive Rule 23.1 with particular facts? We don't know the facts. And we would say, well, you have the Securities and Exchange filings, you have the Wall Street Journal, you have other media that you can look to, and you can also get books and records. Look at this 220. It's a wonderful way to get information. And so we've developed a jurisprudence of Section 220 as the way to go. And these plaintiffs had not done that. And if they had, they might have been able to, as it turned out, express something that was actionable.
As it turned out, they did, in fact, use 220, and they wrote a complaint that was much different than the complaint that you focused on back in 2000. Among other things, they learned that while they had pled that the board had approved the no-fault termination of Ovitz, which allowed him to get his full termination severance package, in fact, the board hadn't acted at all as a board with respect to that termination. And so they found that out through the 220. They amended their pleading, and then that fact that the board, qua board, had not acted with respect to the no-fault termination was one of the key facts that really drew the chancellor's ire when he wrote his opinion on the next motion to dismiss, where he denied the motion in really pretty critical terms, critical of the defendant's behavior, saying many, many times in the opinion, if these facts as alleged are true, this looks like bad faith to me. This looks like a conscious disregard of duties. And so I think that the Supreme Court strategy of directing the plaintiffs to 220 to see if in fact they could put forth a complaint that was viable and that would present tribal issues did in fact work. As you left the bench before the trial and appeal was heard in 2006, I believe it was, before then Chief Justice Steele's court, did you follow the litigation to see how it evolved?
Greg, I saw your final argument before the Supreme Court.
Were you present that day?
I was present that day in the Dover courtroom because I had an opportunity to go and hear the argument. I didn't know anything about the case. I didn't know much about the case this decision in Brem versus Eisner was the year 2000. I retired from the court in the spring of 2004. I believe the chancellor's next decision on the second motion to dismiss was a year later, 2005.
It was actually 2003.
Okay, 2003, right.
But then that was not appealed.
Right.
So we went to trial.
His final decision was 2005 after
Yes,
trial. Okay.
exactly.
And the Supreme Court decision was 2006.
Yes.
So I did read all that.
Yeah.
That's what I knew about it.
And did you, as you sat and watched the argument that day, I mean, I know you weren't on duty, but did you form any view as to where you thought this thing was going in terms of potential reversal on appeal?
I thought it would be affirmed on appeal. Probably I was dazzled by your spectacular argument, but I did think it would be affirmed on appeal.
It was, as we talked about with Dave McBride and Ann Foster, it was a case that had legal issues, but not very complex issues. It really was a fact case.
It was.
At the end of the day, it was a fact case, and all of these directors came up and testified one by one. The chancellor made factual findings, and so by the time we got to the second appeal, there really wasn't a lot of meat left on the bone, was sort of our perception.
And that was a correct perception as I saw it, as an outsider looking at. Reading the chancellor's opinion, two opinions, motion to dismiss, as you said, was in '03, and his opinion on the trial, at the trial on the merits in '05. I got a pretty good education about what the issues were, and it was a fact case. And I think when we wrote Brem versus Eisner, we said, this is a fact case. The facts are very intricate. I don't know whether they were complex, but they were intricate. And that this complaint doesn't paint a picture about what happened and why what happened was bad. So that was in the back of our thinking.
Well, Supreme Court's decision, your decision, Brem versus Eisner, really did pave the way for the rest of this litigation, and of course it turned into one of the most closely followed litigations in Chancery history. I think the other part, not just the Disney case, but the other part of Brem versus Eisner that has really resonated, it wasn't the first time, you're right, but it was certainly a high-profile instance of the Supreme Court pushing the plaintiffs to 220.
Yeah.
And the law has really changed in that way. When you were practicing with Richards, Layton, and Finger, 220 was a rarely used vehicle that was never something that we worried that much about. It has become, well, from the defense side, it has become, here we are in 2017, a major vehicle by which stockholders learn facts about transactions they might challenge, and very frequently used. And it's no longer simply a 6 inches or a foot of documents that are produced in 220 actions. It often many hard copy documents, but volumes and volumes of electronic discovery.
One of the things that we were concerned about with this poor complaint that was in front of us was that the defendants were arguing that we had to pay a lot of deference to the chancellor's decision on the motion to dismiss, because some cases had said on a motion to dismiss for failure to make a demand under 23.1, the scope of review was the abuse of discretion of the chancellor in doing that. And we said, no, we think that's wrong. We have said that in the past. We think that's wrong. And we think that it should be a plenary de novo review, because we can read the English language as well as the chancellor can. And we thought that was part of the problem with this case, was that the chancellor had paid a lot of, had given the benefit of the doubt, if you will, to the plaintiff's pleading, and we thought that, well, we don't have to follow that benefit of the doubt. We can look at this pleading and decide for ourselves. And so we made that doctrine of the scope of review, henceforth, that's the way it'll be. And all the cases you read now, when you read a citation that says overruled on other grounds by Brem versus Eisner, in that one instance.
Very important, because it is just a paper record. It's a complaint, and you're testing the legal sufficiency of the pleading, and that is certainly something that the appellate court is able to do in the first instance.
And we had a lot of cases, in fact, some opinions that I had written where we parroted that discretionary language, and then we finally came to this one and said, why should we do that?
When you look at the many decisions that you authored in your 12 years as Chief Justice, Where does this one fit in terms of importance to you personally? Is it in the top 10 opinions, top 5?
I don't know. I haven't thought about that, Craig. It's an important decision for that scope of review question, but there are other important decisions, you know. As I was saying in the last session, common law judges like we are have a lot of things they can do, and we can overrule the interspousal immunity on torts and so forth, and those are important decisions, and we have a lot of other important decisions. This is an important corporate opinion because of that scope of review thing, I think.
You'll recall that the Council of Institutional Investors filed an amicus brief in the Brem versus Eisner litigation. What impact did that have, and what was the court's general view toward the importance of amicus briefs?
The court, in certain cases, does like amicus briefs and does think that they move the needle a little bit in terms of looking at a broader perspective of this. In this case, I think we realized what the Council of Institutional Investors was about. We knew those people. We knew a lot of those people. And we knew what their point was. Their point was that the process used by the board of directors in this case was not a great example of best practices in corporate governance. And we got that point. And it was not the best practices, as the courts have said all along in this case. The Chancellor said that, and Justice Jacobs said that in his final decision. But that's not how you measure fiduciary duty. And we said that's important for the optics, that's important for how they behave and how they do that. But I think we said, in this case, in Brem versus Eisner, in a footnote, that we considered that. We thought that was important from the overall perspective of corporate governance, but best practices are not how you define fiduciary duty.
You did, in fact, include that discussion and talked about aspirational concepts of,
Exactly.
Of corporate governance that were, in fact, important, and they should be emphasized, but nonetheless, they may, in fact, not be, and they're not standards of liability.
But they can lead you in a decision, in a direction as a director where you are more conscientious about how you handle the process, and that can save you from liability, because I think we might have even said this, these are very good aspirational principles to follow generally, and sometimes can help avoid liability. Maybe we said that, maybe we didn't.
You did have that thought and expressed, and I think one easy example is that with respect to Ovit's non-fault termination, which enabled him to get the $100 million plus, there was no full board meeting. There was no discussion of directors around a table able to react to each other's thoughts and form a collectively informed view. Certainly many observers would say that's not the best corporate practice, corporate governance practice. But nonetheless, it did not lead to a finding of bad faith, which of course is a concept of conscious disregard of duties. And so that's maybe an important example of where things could have been done better, surely. But the fact that they weren't done in an A+ way did not mean necessarily that there would be personal liability for directors.
And the lack of good faith has been an enduring underlying issue in all these cases, with 102B7 eliminating personal liability for due care violations. There's been always a focus on bad faith and what it is, and that law has been developed in this Disney case, not our opinion, but later opinions, and in Stone versus Ritter on the oversight. So that's the law now, and it's quite clear that that's got to be the target if anybody wants to challenge an action. Lack of good faith and conscious disregard of a non-responsibility.
Let me just, anything else you'd like to add about this case, Your Honor? Let me just say this on a personal note, and I hope that the personal note is okay in the setting that we find ourselves in. I was privileged to be your partner here at Richard, Sladen & Finger, and you were always someone who stood for integrity, decency, doing the right thing here at our firm. And then when you went to serve all the citizens of Delaware as the Chief Justice, you carried on that tradition. And we Delawareans are very much indebted to you for your service to our state.
Well, you're very kind.
All very true.
Let me just add that my work here at Richards, Lane and Finger for 34 years, in that work, I was surrounded by really good people like you that were kind of younger than I, and people like Ned Carpenter, who was older than I, and it was wonderful. It was a great learning experience in the skills of an advocate and in the integrity, ethical part of it. And then, as a member of the court, not just as Chief Justice, but as a member of the court, I've been very impressed with the way the Delaware Bar has behaved in those areas of integrity and civility and so forth. Sometimes there are aberrations, and we've tried to bring people back to the right place on those aberrations. But on the whole, the Delaware Bar has just been outstanding and wonderful, and a great example to other bars about how to do it the right way.
Professionalism really became sort of a theme of your tenure as Chief Justice. How and why did you adopt that?
Because I thought it was an easy thing to talk about in my first State of the Judiciary message. Because it got to be that toward the end of my career as a trial lawyer, that I was seeing more and more of this Rambo tactics and that kind of thing. And I just decided that what I really wanted to start off with, instead of getting into any legal doctrine or anything like that, was civility and professionalism, and kind of set the tone for that. That's how and why I got into it. It was low-hanging fruit for me.
Well, it served us all well. Thank you, Chief Justice.
Thank you.